Chapter 4: Laws on Partnership and Corporation. For any partnership to work, the element of trust is essential and is more important than the resources, skills that the partners actually bring into the business. For corporations, good governance and transparency is essential because of the public trust. Learning objectives differentiate the various kinds of partnerships and corporations, the responsibilities of partners and incorporators, identify the requirements in the formation and dissolution of partners and corporations. The law, Article 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Discussions of the law, partnership and associations of two or more persons to carry on and co-owners of a business for profit. The definition of partnership does not include religious associations, conjugal partnerships, and other of a similar nature, because a partnership is defined by law refers only to association for purpose of which is to obtain profit to be distributed among the partners. The essential requisites of a partnerships are an agreement to contribute money, property, industry to a common fund. This is complied with if. Intend to divide the profits among themselves. This is complied with if. Partnership is established to obtain profits. Profit must be common to all the parties, and profit or loss must be divided among the partners. Advantages of forming a partnership. Easy to form. Partnerships are easy to form. If the business is simple enough and the partners are few, the agreement need not even be written down. Creating a corporation is more complicated because formal documents must be placed on file with public authorities. Second, it improves growth possibilities. Partnerships make you more competitive, you get more exposure, offer up a better product or service, and position your business more strategically in the marketplace. No matter how long you've been around, partnerships enable you to grow faster with a stronger competitive advantage. Freedom from bureaucracy. In a partnership, the advantage of freedom of bureaucracy lies in the streamlined decision-making process. Partnerships often have less stringent regulatory obligations than corporations, enabling quicker responses to market changes. This flexibility fosters a dynamic operational environment where partners can readily adapt strategies and make decisions without navigating extensive bureaucratic hurdles. Disadvantages of forming a partnership. Instability. One disadvantage of forming a partnership is the potential for instability due to differences in decision making and conflicting interests among partners. Without a clear agreement on rules, responsibility, and strategic direction, disagreements can arise, leading to instability in the partnership. Another notable disadvantage of partnership is the difficulty in obtaining large sums of capital. Partnerships often face challenges in raising significant funds compared to corporations, as they rely on contributions from individual partners or external sources. This limited capital may constrain the partnership's ability to expand, invest in large projects, or compete with businesses that have easier access to substantial financial resources, such as publicly traded corporations. In partnership, a significant disadvantage is that the entire firm can be tied to the acts and judgment of one partnership as an agent. Each partner in a general partnership is seen as an agent of the business, and their actions can legally bind the entire partnership. This means that if one partner can make a poor decision, incurs debts, or changes in other liabilities, all partners share the consequences, potentially putting the firm at risk due to the actions of a single individual. An additional disadvantage of forming a partnership is a difficulty in severing partnership ties. Dissolving a partnership can be a complex and time-consuming process, especially if there are disagreements among partners or if there is no clear exit strategy outlined in the partnership agreement. Untangling shared assets, liabilities, and responsibilities can lead to legal complexities, financial disputes, and emotional strain among partners, making the process challenging and potentially detrimental to the business. Forms of partnership. A partnership can be any form, even if not recorded at the Office of the Securities and Exchange Commission, except when it is stipulated. When immovable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory of the immovable properties and signed by the parties. Otherwise, the partnership is void, and in case of limited partnership, the parties must sign and swear to a certificate which shall state, among others, the name of the partnership, adding the word limited and the characteristic of the business. File for record the certificate in the office of the Securities and Exchange Commission. Obligations of the partners. Where contribution is money or property, if a partner promises to contribute money during the celebration of the contract and he fails to do so, he shall pay the interest and damages from time he should have complied without need of any demand. If a partner promises to contribute specific determinate things, he must preserve the property, deliver the fruits from the time of agreement, warrant against eviction and hidden effects, transfer ownership, delivery to the partners, pay damages for the delay without necessity of demand, and bear the risk of loss before delivery. 2. Where contribution is industry. An industrial partner, a partner who merely contributed industry or services to the common fund, cannot engage in the business for himself unless the partnership expressly permits him to do so, and if he should fail to do so, the capitalist partner may either exclude him from the film or avail themselves of the benefit which he may be obtained in violation of this provision, with the right to damages in either cases. 3. Obligation of the capitalist partner. A capitalist partner, a partner who contributed money and property to the common fund, is prohibited from engaging in a business in competition with the partnership, unless there is stipulation to the contrary. Otherwise, all profits of such partner belong to the partnership, and all losses shall be for his account. 4. Responsibility between partnership and partner. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership. It shall also answer to each partner for the obligations that he may have contributed in good faith in the interest of the partnership business and for risk and consequence of its management. 5. Sharing of profit and loss among partners. The distribution of profits and losses shall be in conformity with an agreement. If only the share in the profit is agreed upon, the share in the losses shall be in the same proportion. A stipulation which excludes one or more partners from any share in the profit or losses is void, but an industrial partner shall not be liable for losses. In the absence of stipulation, the share in the profits and losses shall be in proportion to the respective capital contribution, except in the industrial partner, who shall receive a share of the profit as may be just and equitable under the circumstances. 6. Property rights of a partner. A partner cannot assign his right with respect to the specific partnership property for the partner's individual debts or legal support. However, a partner can assign a share in the profits to a third person, the right to participate in the management as governed by stipulations of the partners. If none of the partners participate in the management, the powers of the managing partner appointed in the Articles of Partnership cannot be revoked despite opposition, except by partners representing controlling interests and provided there is just a lawful cause. However, powers of the managing partner appointed after the formation of the partnership can be revoked anytime. If two or more partners are appointed managing partners, each one may separately skip all acts of administration, but if opposed, the majority among the managing partners shall prevail. If there is no majority, the partners owning controlling interests will decide. 7. Liability of individual partners to third persons. All partners, including the industrial partner, are liable pro rata with all their properties for contracts with third persons provided they were entered into the same and for the account of those partnership under its signature by persons authorized to act for the partnerships and the partnership's assets are already exhausted. 8. Liability of the limited partner. A limited partner is liable as a general when he allows his surname to appear in the partnership name and when he takes part in the control of the business. In this case, he shall have all the rights and powers and be subject to all the restrictions of a general partner except that as to the other partners. He shall be preferred as to the return in his contribution and share in the profits. Thank you, everyone. This is Rhea Ranario, BSH 3A.